Now back to our leading story this hour. Criminal law expert Zola Majavu joins us as we continue to unpack today's events at the Bloemfontein High Court in the Thabo Bester case. Zola, thank you so much for your time and for joining us this afternoon. Maybe let's just take a step back and get your sense of how significant is the pre-trial phase in determining the ultimate outcome of a legal case such as this one.
Good afternoon, and good afternoon to the viewers out there. It is absolutely critical for the commencement of a criminal trial, not so much the outcome thereof. You would appreciate that there is a multiplicity of accused persons and similarly a multiplicity of defense counsel. Now, in such instances, a court would want to be sure that when a matter is enrolled for trial, all the preliminary issues that could potentially affect the smooth proceeding of the criminal matter when it does get underway are resolved ahead of time. For example, how many witnesses are going to be called, which would have a direct bearing on how many days could the court enroll the matter for? How many attorneys are involved? Whether or not these attorneys have been placed in sufficient funds, which we as lawyers euphemistically refer to as financial instructions. Whether or not any of the affected accused persons would be speaking a specific indigenous language, and if that is the case, are arrangements in place for the interpreters to be made available, whether or not there are issues that could be resolved between the parties as common cause, and therefore without requiring them to be specifically proved in a subsequent criminal case. All of these issues must be resolved beforehand. Failure to do so, you may result in a trial that starts and it stops midway through because one of the lawyers says he has not been paid, or the state has not given them a particular document which it intends to rely upon, and they hear of it for the first time during the stanza of the proceedings. That will invariably cause the trial to stop, for the defense counsel to then be given copies of that which they say they were not given. And all of these things have a direct impact on the smooth proceeding of a criminal trial. So it is not unheard of. In fact, it is now a requirement in the High Court that before a matter is enrolled for trial, all of these procedural issues must be resolved. We've just seen today that some of the defense counsel withdrew. They have to be replaced by others who themselves must be brought up to speed. And all of these issues must and should be resolved in a pre-trial conference. So what transpired in court today was completely unsurprising, and that is the correct way to go about it.
I mean, the pre-trial, as you explain, it looks into the administrative issues before this trial, and with the trial now being postponed to the 5th of June, and what we witnessed this morning, how much more admin do you anticipate still needs to be done before this trial actually gets underway?
Quite a lot, and let me just correct you. What was postponed to the 5th of June is not a trial. Is a pre-trial that itself could not get underway today due to a number of these developments, some of which related to issues that, in my respectful view, ought not to engage the attention of the court. I'll just touch on it briefly. For example, the food that Mr. Bester may or may not have wanted to eat, the issue regarding access to telephone. Those are issues that are governed under the auspice of another arm of government, or of the state, which is the correctional services, because he is, after all, a sentenced prisoner. But be that as it may, in terms of the administrative issues that are yet to happen, for example, the state is yet to provide the defense with a docket. One can assume or expect that it is going to be quite a voluminous docket, which must be studied beforehand, and having read the docket, all or either of the defense counsel may take the view that they wish to request further and better particulars from the state, or they may wish to make written submissions, which would have to be considered by the Director of Public Prosecutions in the relevant province, in this instance in the Free State. One does not know how long the Director of Public Prosecutions may take in considering those representations and what the outcome thereof may be. So it is quite possible that come the 5th of June, in the event representations or a request for further particulars were to have been made, there may well be a situation where those have not been complied fully. And if that is the case will be postponed again for another pre-trial. So a pre-trial is basically a last step before the matter is enrolled for trial, and a determination is made as to how many days do you need for this particular trial. 2 weeks, 24 days, as the prosecutor alluded to. It may well not be the case. We don't even know whether some, upon receipt of the docket, may decide to turn state witnesses, or some may decide to plead guilty, or they may wish to enter into a bargain arrangement. All of those things are still a long way coming, and they would not even engage the attention of a judge who is case managing this particular pre-trial conference. So there's a lot that can still happen. So I wouldn't hold my breath that by the 5th of June we will know when the matter will be enrolled for trial. If that happens, then well and good. But I think from my own experience, there seems to be a lot that needs to happen, especially taking into account that you have a multiplicity of counsel who may adopt different defense strategies. And as you have seen in the Senzo Meyiwa matter, these issues just happen on a daily basis. But what the judge, I think, is trying to do here is trying to be very cautious to ensure that when a trial is indeed enrolled, all of these administrative issues have been resolved, and both parties will then be held to a commitment that they would have given to a judge. For example, you will not be allowed to withdraw as counsel on account of non-payment of your fees, when you would have confirmed during a pre-trial that my fees or a substantial amount thereof has been secured. You will then be told you're going to proceed with the case because during the pre-trial, when asked about this issue, you indicated that you were covered. In fact, this is the point that one counsel raised, who cautioned the state about the fact that a confirmation regarding the fees is premature. I agree with that counsel. He was spot on. You can't even begin to talk about confirmation that the finances are secure when you have not even received the contents of the docket, because the docket will inform how long any counsel will take to read it, to prepare, to consult, and consider other aspects or other steps that they may wish to take. That consideration doesn't arise for the state because they rely on the resources of the state. So it is a concept that is foreign to the prosecutors because whatever they want, someone pays for it. The same is not the case for accused persons because some of them have to dig into their pockets or they have to rely on legal aid, which may or may not move at the speed that we all anticipate to expect them to. And legal services don't come for cheap. It's quite an expensive, lawyering and lawfare is quite an expensive exercise. But unfortunately, every accused person has constitutionally guaranteed right to legal representation. So the wheels of justice are going to grind much, much more slower on this particular case. Otherwise, if they rush, they're going to crash.
And then what would then be those implications with these unforeseen postponements, the defense declaring at this point that the funds are readily available, and they do get to a time when the funds are not available? What happens in such an instance?
This is precisely why a judge who is case managing a type of case like this one would be slow to enroll it for hearing at the trial proper. A judge would want to be satisfied that all of these issues, foreseen and unforeseen, have been mitigated for, or there is a contingency plan in the event they were to arise. The implication is that it will take a bit of time before the trial commences. That is the unfortunate implication, but it is the better devil of the two, in the manner of speak.
And might a pre-trial bring any light in terms of gaps or weaknesses in the prosecution's case?
Not necessarily. The disclosure of the content of the docket will share that light to the counsel who take the trouble to read that particular docket and consult with their respective clients. But it is not something that you will see playing out in an open court. I know we are all itching with curiosity as to whether or not is Bester in fact the Bester that everybody talks about. There could well be other DNA-related issues, and the defense is under no obligation to disclose the ace that they have up their sleeves, if they have any. But the prosecution is forced to disclose whatever it intends to rely upon to the defense well ahead of time, well ahead of the pre-trial. And if they were to see gaps, any smart lawyer would not want to blurt out what those gaps are, at least until the right and opportune moment. So I think from a public curiosity point of view, you are unlikely to know what those gaps are, if there are indeed any gaps, on or after the 5th of June. It is something that lawyers will keep close to their chests. But they may hint in the form of representations that they may make to the Director of Public Prosecutions. It is not uncommon that having received the docket, as defense counsel, you may then write to the DPP and say, look, having perused this docket, I do not think they disclose an offense against my client, or we have a perfect defense. And in some instances, if the DPP is persuaded, it may result in the charges being withdrawn. This has happened on a number of occasions where people were paraded in front of the cameras, and later the state comes back and says, hey, we don't believe that we've got a good case, and charges are withdrawn. So this may also happen in this instance. I think we must be very slow to want to impute the court conclusions on what is publicly available in the public domain. I think there's going to be a lot of rabbits that are going to come out of the proverbial heads in this case. I'm not even sure if Bester is Bester. I'm not even sure if all of those who are alleged to have connived, the state might be able to link the dots in a manner that will pass the test. The test here being proof beyond reasonable doubt. Not conjecture, not what we think is exciting from a public point of view, but the law is not about the truth. The law is about the truth that can be proven. I know it sounds controversial, but I'm putting my foot on it. It's not so much what we think we know. It is so much, and it has everything to do with what we can prove. If you cannot prove beyond reasonable doubt, and there is some element that Bester may be Bester or Bester may not be Bester, the person that is currently arraigned is entitled to what is called the benefit of the doubt.
All right, Mr. Zola Majavu, thank you so much for your inputs this afternoon. That's criminal law expert Zola Majavu giving us his take on the start of that pre-trial of the Thabo Bester case. Now on to